Welcome everybody to today's webinar. Today's webinar is on social media compliance, safeguard your brand and avoid common pitfalls. Today, you'll be joined by myself. My name is Sam Andrews. I'm a business development representative here at LegalVision. Also joining us today is a fantastic Caroline Snow. Caroline is a senior lawyer here working out of LegalVision's commercial and regulatory team. So before we begin, everyone, just a couple quick housekeeping items. So you will receive an email after today's webinar with the recording and the slides. Okay, so we hope you guys can all stay for the full duration of today's webinar. If not, be rest assured that you will be sent the recording, so it will be sitting in your inbox after today's session. Also, please submit your questions into the Q&A box. And at the end of this webinar, Caroline will be so kind to take us through and answer any of those questions that were asked. Lastly, please complete the feedback survey after the webinar. Obviously, today's webinar is a free webinar. Nonetheless, we're always working really hard here at LegalVision to improve our system and improve our webinars and the content that we bring to you. Now, by viewing this webinar, you're actually eligible to receive a complimentary consultation with us here at the LegalVision team. So we'll have a discussion around how we can help your business. In this consultation, we'll have that discussion about your business, your growth plans, and how we're able to assist to set you up for success from a legal perspective. Now, to claim this complimentary consultation, feel free to leave your contact details at the end of the survey, at the end of the webinar where the survey appears. Otherwise, certainly feel free to contact us via our website. Now, I'll be handing it over to Caroline to take us through this webinar. Caroline, over to you.
Thanks, Sam. Hi, everyone. So today we'll be chatting about misleading and deceptive conduct. The kind of structure for the webinar is we'll be looking at, what that means in the social media marketing context, some social media specific challenges, ethical management of customer reviews and social media content, influencer partnerships, and other types of promotions you would typically use on social media, including trade promotions and offers. We'll be exploring how the Australian consumer law applies to social media marketing and the critical compliance considerations for Australian businesses that you need to understand. The principles we discuss today will be mostly relevant to social media, but can also be applied to other advertising mediums, more traditional types like radio, TV, and print. So to kick things off, we'll be touching on misleading and deceptive conduct in the social media marketing space. The main section of the legislation that we're looking at that relates to this is Section 18 of the Consumer Law. The two fundamental principles that apply in this area are that businesses will not engage in conduct that is likely to mislead or deceive, and businesses must not make false or misleading claims or statements. This section of the legislation can be interpreted quite broadly. So it's for general business conduct, but also specifically for advertising and social media. But it also covers things like your product packaging, statements that you might make about your businesses online as well. But it's quite broad. The main considerations we need to think about when applying this to marketing and online social media advertising is we've got to take a piece of advertising and marketing material and look at it holistically and ask whether, the content is likely to lead a person or a consumer into error. The content, does it include any statements or representations, as well as information that, are we withholding something when we make those statements? What is the overall impression of the advertising, and what's the likely effect on the target audience? So, whether the overall impression created in the recipient of that advertising, whether that's likely to be misleading or deceptive. And then the other key point here is that intention behind the advertising doesn't matter. So even if your intention was not to mislead someone, if that's, the overall impression holistically of the advertising, when we look at it, it doesn't matter that you didn't mean to, it was in fact misleading. In any case, what you need to be considering when reviewing advertising material for social media is whether the conduct or the content that you publish, whether it's likely to lead someone to believe that something isn't true or is incorrect. That's where there's a risk that you're engaging in misleading and deceptive conduct. It's also important to note that just because you're publishing the content on social media, and we'll get into this in a bit more detail in a moment, doesn't make this different to any other type of advertising medium like print or TV or radio. So now we'll be moving on to social media specific challenges. I think, as we've mentioned, these principles apply to all advertising mediums. Unlike traditional advertising, social media presents some more unique compliance risks, specifically around, character limitations, for example, fine print on disclaimers. Obviously, for your social media marketing, you typically wouldn't have the full version of your terms and conditions or as much product detail that other advertising might have. So I appreciate that in some circumstances you are limited in what you can say. So when you're working with a smaller word count, we need to be quite careful about what you're saying, and again, what kind of impression that creates on the consumer. The other major issue in this space particularly is, whether the images and videos that you're using in this type of marketing might be inconsistent or contradict the text of the advertising or any disclaimers that you put to mitigate those sort of risks. An example of this that's relatively recent is a Samsung case where, in that particular context, Samsung was ordered to pay $14 million for showing their Galaxy phones being used in pools and seawater as part of their advertising. And the advertisement had some text that said, do everything you love this summer with the Galaxy A5, capturing your Sunday surf session at the beach. The overall issue with this is that this advertising created an expectation or impression on consumers that the product could be used in water and seawater particularly without any damage, which, was not found to be the case. So that's the sort of a really good example where the text and even the wording, and, there probably are some parameters around this particular product having some waterproofing capabilities, but not to the extent that it was represented in the advertising itself. Now, the next major consideration that we, kind of need to think about, or a common kind of pitfall for businesses when advertising online, is saying something is absolutely free, or, representing that, maybe there's a free consultation as part of the services, or some aspect of your product is free. But if it is contingent on, anything else or any other condition that the customer needs to require, if that isn't clearly communicated at the time the customer is taking up that offer, there's an argument that it's misleading and deceptive. A common example of that is buy one, get one free. That does really kind of spell out you've got to do, meet XYZ condition. So, make the first purchase and then get the second one free. Where something like that might be, misleading is where there's an extra condition that you haven't mentioned in the advertising. So if it's buy one, get one free and sign up to our mailing list, if the mailing list component isn't represented or clearly advertised, then it's likely to be misleading. Another thing to think about when it comes to putting together social media marketing and avoiding misleading conduct is, knowing your audience and who you're trying to target, and maybe, that you can take into consideration the type of the social media platform that you're using. So, TikTok might be a different generation to Facebook marketing campaigns at the moment, but, noting that if your demographic or your target audience is going to be youths, keeping in mind that the type of advertising you use and the way you frame things, again, is going to be factored into, whether something is misleading or not. It's that holistic impression that you're making on the consumer, noting, who's likely to receive that marketing as well. So the next point we'll touch on is ethical management of customer reviews and social media content. What, as a general matter of best practice, is you should only be collecting genuine reviews rather than paying or incentivizing people to leave positive reviews. If you are doing some sort of collaboration, like influencer marketing, and we'll touch on this in further detail, that's not prohibited by any means, but there are additional disclosure requirements where you're offering incentive for that review. Don't write any fake reviews about your business. Don't manipulate the reviews by creating your own or asking people who've never used your services or products to write a review for your business. That is likely to be considered misleading and deceptive conduct because it's not a true or accurate reflection of the services. Notably, you can't exclude or alter negative reviews either. So it is one of those things where it's going to impact the overall impression that's left on consumers and is likely to mislead them if those types of reviews are removed. What I would say, to the extent that a customer has left a review that is fake or it's untrue, there are steps you can take about that, which I'll touch on later in the presentation. And there is a really useful resource that is available for download. I think there's a QR code linked at the start and end of this presentation that you can download for more guidance on what to do when that happens. So as a key takeaway, when you ask people to leave reviews, if you are going to offer an incentive, all incentives should be applied equally. So that applies whether someone leaves a positive or negative review. You need to clearly disclose any relationship that affects the impartiality of the review. So that would be if there is an incentive offered, for example, you should be disclosing that. You shouldn't change the review once it's been posted or displayed to make it more positive or manipulate it in any way. And you should also ensure that customers know how you will be using their reviews if they do leave one. An example of how businesses tend to manage this in practice is that you might have a clause in your terms and conditions with an order that says, if they leave a review or they send a photo to you of their use of the product that's really positive or favorable, if you want to repost something like that, typically the practice would be getting consent. And one of the ways you can do that is by having a clause that reflects that in your terms and conditions. Now, when it comes to reviews and social media, the ACCC is fairly clear that businesses are responsible for review content that's posted on your social media pages, regardless of whether that's the business itself posting that content or whether that is someone leaving a comment on the Facebook page or sharing their experiences on social media and tagging you or something to that effect. There was a federal court case in 2011, a little while ago, but it's still relatively still relevant. But basically, the federal court found that companies are responsible for their fan posts or testimonials on social media pages when they knew about them and elected not to remove them. And in that case, it was found that this business was misleading by not removing certain testimonials from Facebook followers and Twitter followers at that time. And so this is particularly important if you're working in a regulated space. So, for example, what I mean by that is, if you're selling therapeutic goods or medicines and things like that, the TGA also applies to those types of businesses and takes, a relatively harsh approach where social media comments from customers are inconsistent with the therapeutic goods legislation. Again, the ACCC also has the power to do that, but we haven't seen that pop up as a bigger risk. So it's certainly an issue in regulated spaces. Now, for moderation practices when it comes to your social media pages, our recommendation generally is that you have a moderation policy and you check in on the type of content that's being shared on your social media pages, and you take steps to remove any false, misleading or deceptive posts when you become aware of them. I appreciate that this can be, a sort of resource consideration for most businesses, but it is important to make sure that those misleading and deceptive claims about your business are monitored and removed if they're inconsistent or incorrect. The other point, so when it comes to sharing reviews from your customers, and we briefly touched on this before, but if you want to share a customer review, the best practice recommendation would be that you get permission to repost that customer's photos or videos if they're relevant or included as part of the review. The main reason for that being that the customer likely owns the copyright in those photos or videos and the content in the text of the review, if it's got any like creative expression in there, and taking steps to attribute, the owner of that review and things like that. The additional point to consider in this space is the privacy implications. So if you are sharing a review of a customer, again, typically you would have some personal information that's attached to that. So it could be, someone's name, their email address, contact name, or, username on the social media platform, if it's Instagram or something like that. But just being mindful that, you can't use their information in a way that's inconsistent with their purpose it was collected for. Typically, you would collect their information to provide them with your goods or services. So reposting their information, isn't directly related to that. So again, best practice is to get consent to share that information. So there's basically two considerations from an intellectual property perspective, but also from a privacy perspective. Now, for influencer marketing, this is a, ACCC enforcement focus. The main thing to take away in this space is that if you are looking at any influencer marketing, you have disclosure requirements. The ACCC has clarified that any, benefit that's shared with someone triggers these sort of disclosure requirements, and specific examples of that would be, direct payment to an influencer, a gifted product without any like specific posting obligations, ongoing partnerships or ambassadorships, any other form of consideration or benefit. So it can be that you're obviously doing some sort of formal engagement where you've said to the influencer, I want you to create 3 TikTok videos and I'll pay you $50 per video or what have you. But it could also be, the scenario where you gift them a product and ask for a video in return. Or again, you just gift them a product and they choose to make one of their own volition and you decide to share that. All of that type of relationship requires disclosure. And if you haven't, disclosed that information, it's likely to be misleading and deceptive. An example of this in recent times is La Mer, the beauty brand, essentially, provided some gifted products to a particular influencer who, posted about the products and said, thank you. While there was no payment and there was no obligation on the influencer to actually post about the products, in this case, the ad standards, which is one of the other regulated bodies, found that by sending the product to the influencer, knowing that they had a substantial social media presence and would likely post about the gift, they found that the thank you in and of itself wasn't sufficient enough to disclose that relationship. And so what we sort of look to again is more prominent and clear disclosure around this. I've got some examples of what would be proper disclosure on the slides that you can read about. And again, the placement of these hashtags is fairly important as well. So it could be disclosed verbally. What you would see as common practice is that it's usually in the caption or description of the video as well. But yeah, the more disclosure, the better. When it comes to, I guess, more organic types of advertising and working with influencers, again, if you're, scripting the experience and giving fairly detailed instructions to the influencer on what they should be posting as part of the scope of the services, there is a bit of an issue here where potentially it's likely to be misleading and deceptive because, once again, it's not going to be an honest and genuine review. And by giving specific directions and instructions and limitations on those influencers, you kind of limit the accuracy and truthfulness of the review overall. Also making sure, as a general matter of best practice, like auditing any sort of influencers that you're working with to make sure that they actually are, you might have a written agreement in place with them that says they need to disclose the relationship when they post this content, but you need to make sure in practice that they're actually doing that as well. So just keeping an eye on what they post, particularly when it comes to your branding. Now, the other consideration specifically for influencers that I'll just briefly touch on is when it comes to engaging them, lots of businesses aren't aware of this, but influencers are typically considered employees for tax purposes. So all that I mean by that is that there can be some superannuation obligations that you need to carry through. So making sure you have like a formal written agreement in place with these service providers that you're working with, and just ensuring that that is compliant with the tax legislation. There are scenarios where, if super obligations aren't fulfilled, that directors can be personally liable for those unpaid taxes, really. But yeah, that's probably not the central focus of this presentation, but that's something to keep in mind when working with influence as well. Super common pitfall for our clients. Other types of promotions that you might run on social media as an advertising and marketing strategy are trade promotions and kind of general offers. What we would see for trade promotions, the most common type is a game of chance. Game of chance are heavily regulated. The legislation varies state by state, but if you're offering any sort of prize that's valued over $3,000, typically you would need a trade promotion permit in at least one state if you're running the promotion nationally. For game of skills, which would be, say, as an example, you post on social media and ask customers to tell you in 10 words or less why they like summer or why they like using your product in summer or something to that effect. Because you're typically awarding the prize based on the most creative answer, that's a game of skill. Game of skills are only regulated by the consumer law, so you don't need to comply with the community gaming legislation otherwise. In any case, for both of these types of trade promotions, the big issue is, bigger issues are how you advertise them. Making sure, again, that any terms of entry, ideally you have express terms and conditions about how the promotions will operate. For games of chance, you have to have that to meet the regulation requirements. But when it comes to advertising these promotions, again, I appreciate that for social media, you are constrained in some way about how you advertise it. For games of skill, being fairly specific about what the entry and participation requirements are in any advertising, in those captions, things like that. And for games of chance, there are like minimum advertising requirements that the various state regulators actually have to have, or, it's a requirement of the law to have with any of your social media marketing when you post and share the information about a game of chance. To run these types of promotions, at least for the game of chance elements, the trade promotion must be like for the genuine promotion of your goods and services. It needs to be conducted by a legitimate business. It needs to be free to enter. And again, like we've mentioned, have clear terms and conditions. The terms and conditions would typically need to include, eligibility criteria and any geographic restrictions, the timeline for the promotion, so entry requirement, due dates, deadlines, when to complete things, and when the winner will be announced, the total prize pool value, how the winner's selected, where the results will be published, and then any platform-specific requirements. So that might be, Facebook typically has some additional requirements that you need to meet, or, won't let you run these types of promotions for some types of businesses. I think the other point to consider when it comes to types of promotions you might run on social media, it could certainly be like, what's a really common one is, offering free product in exchange for signing up to someone's mailing list. Again, making sure that you've got terms and conditions that are attached to that offer. So things like, how long is the promotion available? Is there any limitation on the amount of stock or free product that's available? Just being really clear as much as possible. So In terms of the key takeaways about what we have touched on today, the consumer law, and so that misleading and deceptive conduct principle that we mentioned at the start of this presentation, it applies equally to social media as it does to more traditional, media advertising like TV and radio. As a business, you're responsible for all of the content on your social media pages. So that's the content that you publish. It's the content that your customers or followers publish about you or about your goods and services as well. If you are, incentivizing any type of review, whether it's through influencers or just, your customers generally, you should be disclosing that the product is gifted or free. Again, if you're using influencer advertising for paid content, making sure you've got those disclosure like #ad there. For visual content, so photos, images, videos, things like that, making sure that the actual images aren't consistent with any or inconsistent with any text and actually aligned to how your product and services work. If you are going to make any claims about your products or about your business, ensuring that you can substantiate those claims. So, as an example, if you're going to say that the product is carbon neutral or, by purchase of the product, with every product, you plant a new tree based on every sale, for example, making sure that you've got records and data to support those types of claims. Monitoring your social media platform to help avoid any misleading and deceptive conduct. Making sure that your advertising isn't inconsistent with any Instagram or, TikTok policies, depending on who you're working with. And then if you're operating, a trade promotion, making sure you have terms and conditions attached to that. And if it is a game of chance where someone goes into the draw to win something, making sure you meet the other community gaming legislation requirements and the advertising requirements associated with that. Thanks. That concludes the main part of our webinar. You might find this publication useful. So it's the 5 ways to deal with negative or false online reviews. I did mention this earlier in the presentation as being a way if you have, reviews that you don't agree with or are false and untrue and could be damaging to your business. This is a really good resource to consider.
Thank you so much, Carolyn. Really appreciate it. That concludes the main part of our webinar today, everybody, on social media compliance. But I did want to take a moment just to say thank you to Carolyn. That was fantastic. Thanks for running us through that. Really interesting for me also to sit here and learn today. Now, Carolyn's run you through our last publication. I just wanted to bring to your attention that we do have another webinar coming up on the 4th November, 11 a.m. around the construction industry and an update as to what to expect in the coming year of 2026. Now, we're going to answer your questions shortly. While you all take a moment to submit them, I wanted to take you through our LegalVision membership. Now, by becoming a LegalVision member, your business gets unlimited access to our full service commercial law firm. Here at LegalVision, we have over 100 lawyers to look after all of your BAU or business as usual legal needs. We work towards providing ongoing legal support while reducing the overall legal spend of your business and maintaining high-level advice. With us, you have access to an affordable, scalable team, also powered by our industry-leading tech. We have a tech platform here at LV named Prism. What our team can assist you with. So the 3 key points that I wanted to bring up today as to what LegalVision can assist with is firstly our unlimited document drafting and reviewing of your business contracts. Also, we provide unlimited LACs or legal advice consultations. And lastly, I just wanted to mention today that we also provide unlimited domestic trademark registration and of course, much, much more. Now, as a LegalVision member, you don't have to worry about the cost of lawyers. Think of it as having your own in-house legal counsel. We'll take care of all of the business as usual legal work so you can focus on actually running your business and growing your business. If you do have an in-house counsel, we actually also offer a dedicated service to manage your high volume and low value business as usual legal tasks. Now, if you do want to learn more about our membership or our desk extension model and how it can help you, certainly feel free to request a free consultation when the survey appears. It'll appear at the end of the webinar. Otherwise, as I mentioned earlier, feel free to jump on our site and give us a call. Now, we're going to hand back over to our host to answer some of those questions that were put forward today. While they do that, you'll now see a poll question pop up on your screen. So we would appreciate if you could please answer it. That would be very, very helpful to us. Thank you, everybody. Back to you, Carolyn.
Thanks, Sam. So I'm just taking a look at some of the pre-submitted questions. When it comes to, so one of the ones that was submitted in advance is using photographic images I've taken of other companies' advertisements on the street to discuss content and using screenshots of their online advertisements for the same reason. There's a couple of issues here, being that in Australia, photographing street advertisements and screenshotting online ads, so this is from an intellectual property and copyright perspective, for genuine commentary and criticism or review purposes, is likely protected by the unfair dealing exception in the Copyright Act, provided that use and commentary is, fair, transformative, and accompanied by appropriate acknowledgement of the original owner. The challenge with this is that, the fair dealing exemption to copyright, copyright infringement is assessed on a case-by-case basis, considering, the factors like the purpose of the use, the amount of content taken when it's, republished, market impact, things like that. Using competitor ads purely for promotional purposes without any substantive commentary is likely to constitute copyright infringement in and of itself. The other additional issue you have if you're making kind of comparative advertising claims between your business and another business is, if you're going to draw a side-by-side comparison, you need to be able to, ensure that those comparisons are accurate, and again, avoiding misleading and deceptive conduct. So if they're not accurate and you're not comparing like for like products, that it's likely to create issues from a regulatory standpoint where it could be misleading. But additionally, they're fairly high risk in the sense that your competitor might have a problem with you, making those comparisons or even using that IP in their advertising. So again, it's something that needs to be assessed on a case-by-case basis about whether it's appropriate to do that. But, this specific type of comparative advertising creates a number of legal issues. In terms of, I think I'll just take a look at some of the online submissions. So for policies for social media to assess if they are misleading, who polices, it's typically the ACCC. So that's the big regulator for all consumer law issues. Generally, it could also be like Ad Standards is another regulatory body that kind of assesses whether advertising is palatable or appropriate. So examples might be usually they will deal with complaints about like gun advertising is a common example. So, if there's gun advertisements that might be targeting children, it is something that Ad Standards has dealt with recently. In any case, you've got a couple of different regulators. If you're working in a regulated industry, so financial services, for example, it would be ASIC that complaints is going to. For therapeutic goods and services like medicines and medical devices, it would be the TGA that typically deals with that. In any case, it is correct that that would also apply to your web advertising and social media advertising, and that is regulated as well. So to look at some of the other pre-submitted questions, one of the ones submitted in advance was, what are the copyright implications of using trending audio in social media posts? And then, implications of using celebrity images in posts and memes and things like that. Again, in the Australian market anyway, using audio in social media posts without permission typically infringes on copyright ownership. So for the record label or, you know, the musician themselves. Practically speaking, those social media platforms like TikTok and Instagram usually have licensing agreements and arrangements that allow users to incorporate their licensed music library into the content they create. However, downloading that audio and then reusing it for your own commercial purposes and advertising outside of the social media platform is unlikely to be covered. So if you're going to use, you know, popular music in your social media advertising campaigns, particularly where they're paid and you want to use them across multiple social media platforms, getting a license to do so is always best practice. In any case, when it comes to using celebrity images, using them in posts or memes could be a copyright issue because it's likely that maybe the celebrity owns the image, or it could be that a particular, you know, tabloid or news publication owns the image, depending on what it is. And if there are any issues with how it's presented, again, the owner of that copyright is likely to pursue misuse of that. And then there are, like, obviously additional implications where it could be, you know, defamation, depending on, you know, what the post says or whether the meme is inappropriate or damages that celebrity's reputation. Now, just having a look at some of these. So this is Jessie's question. Are we as brands required to advise influencers their disclosure obligations? And, you know, in the influencer agreements that we typically work with for clients, we would recommend having obligations in those agreements for the influencer to make those disclosures. Ultimately, you know, the influencer is acting on your behalf. So it's not necessarily the influencer that has, you know, engaged in the misleading and deceptive conduct, but it's your business that engages in that. That's what the ACCC is interested in. There are ways that you can protect your business by having obligations on the influencer in the contract as well. Obviously, you know, as with any service provider, you can work with a range of different people with lots of experience and I guess inexperience as well. So you'll have some influencers who are super savvy and across these types of obligations who should be quite easy to work with, but I certainly wouldn't say that's true of all of them. So it's definitely something to keep in mind before you engage someone. So one of the other questions we had in advance of this session is if you're using AI for content to create social media posts and advertising, do you need to state that you have used AI and which one? This kind of, you know, covers a couple of different legal areas. The main one I would say that's relevant for us to consider today is whether the content generated by the AI is misleading or deceptive. I suppose when you're creating the content yourself, you have a bit more control over the output, obviously. Whereas when you're using AI, if it is going to be like a completely inaccurate or hallucinated kind of image, or, you know, way your product or services are being used, then that is likely to be quite problematic and potentially misleading. So the main best practice would be, you know, if you are using AI to state that the content is generated by AI, to avoid creating those sorts of unrealistic expectations about the product. The other thing to keep in mind is, depending on the AI model or service provider that you're using, you need to check that you own the rights in the output, that you're, you know, able to repost them or use them for commercial purposes. And then also whether there's any like licensing conditions if you don't own it. So it might be, for some examples, you know, you might be required to post that it's owned by a specific entity, or, you know, disclose that it's created with AI, but it's going to be subject to like the AI terms and conditions themselves. So from another question that was submitted in advance is it legal to post photos of customers without their permission? Best practice would be to get consent from the customer to post those photos, particularly where, you know, if you didn't take the photo and it's owned by someone else, from a copyright perspective, there's an infringement issue there. And again, you know, to the extent that that image might contain any personal information, there's potentially privacy issues as well. So best practice would be to get consent where you can. I'm just having a look at some of the other live submitted questions. So this question comes from online. Is there a way to use pictures and information provided by reviewers with website terms, e.g. by posting or providing such information on the website or on Google reviews, you consent to us using these images? Common practice would be in your like website terms and conditions, or in your like terms of purchase. You might have something like that essentially consents to your use of the images or the text that's associated with that. Ideally, you know, I think the challenge I don't think you can make it as broad as, you know, to cover any Google review, because that's not a review that's left with you. It's left on Google. You know, Google has a license to use it. So the arrangement between Google and the customer is between them, not with your business. So practically speaking, I think it'd be challenging to get consent to share that. But obviously, you know, lots of businesses share Google reviews from time to time, or you might be able to work with, you know, integrate your Google with your web page. An example, like, you know, if you think about Trustpilot, LegalVision certainly uses that. So we've got an integration where you can see our Trustpilot reviews on the website. That's not so much an issue between us and our customers. That's between us and Trustpilot with that integration. So there are steps you can take to get consent if it is one that you want to republish all of the information on Google and you don't have that sort of integration that I mentioned before. You know, you can, of course, reach out to the customer to ask if you can share it, and then you address it that way by getting consent. So for terms and conditions, like offering any sort of freebie when you sign up to a mailing list, it's not so much an issue. You know, our recommendation usually is you're quite specific with terms and conditions, and again with advertising. If you are genuinely willing to offer like a free product, you know, for signing up to a mailing list indefinitely, then practically speaking, you know, you might not put a time limitation on that. The challenge with this, or where, you know, we've seen customers potentially go wrong, is that they want to change the terms of that offer at a later date. And because it's indefinite, or they don't have the rights to amend at any time, because that's where you potentially run into this misleading and deceptive conduct issue, they can't update or just vary the offer unilaterally. And that's where it's likely to be misleading. So, you know, where you can, being fairly specific about the terms of the offer. And again, if there are limitations on it, which would be a time limitation or a volume limitation on how much product is available, making sure that is in your terms and conditions, but also in any associated advertising. I can probably do, this would be the last question that we address. In terms of hashtags, we've talked about paid ads and things like that. I think the risk you run with the hashtag for a collab is that it's probably not specific enough to, you know, communicate to customers that there's any payment involved. There might be scenarios, depending on the commercial relationship, where, you know, if two businesses are thinking about working together, that a collab might be appropriate. But to, you know, it's not immediately clear based on that hashtag that there's any kind of payment or exchange of a benefit. So I wouldn't, you know, by default be saying collab is appropriate for all influencer marketing, for example. I'll hand over to Sam to wrap up. Thanks, Sam.
Thank you very much, Carolyn. I think it's time you go have a well-earned glass of water after all that talking. Thank you, everybody, for joining us today. That's all we have time for. Our apologies if we didn't get to all of your questions. However, if you do submit your details at the end of the survey, and we wish you do, there'll certainly be a spot there to ask any other questions you may have, so we can answer it after the fact. Now, to learn more about our membership, and how it can help you. And I'm referring to that complimentary consultation that I mentioned earlier in the webinar today. Feel free to, after this webinar, claim this consultation, okay, and opt in. We can get an understanding of your business, your growth plans, and explain further how LegalVision can come in and provide a tailored solution to your business. So certainly feel free. We'd love to see you all for a 20 to 30-minute conversation. Now, while this webinar is free, as I also mentioned earlier, we always value your feedback. So please, it's a 30-second survey that pops up at the end of the webinar. Please take the time to fill that out. We're always trying to make our webinars, as I said, bigger and better and more informative to all of you. So we'd very much appreciate the feedback. And thank you, everybody, for joining today. Thank you, Carolyn.
Thanks, everyone.